So these are people, relatively sympathetic to doing the right thing, but nonetheless, we find fairly definitive opposition to the Guam Commonwealth Act. So, and this is the kind of the final moment here in October 1997, when a fellow named John Garamendi comes to Congress. Now, John Garamendi is now in the Congress. So this guy, he's a Democrat. He now represents part of California in the House of Representatives. And he clearly, in his testimony, seems sympathetic to Guam and sympathetic to doing something right. But he says we simply can't accept the Guam Commonwealth Act as written. And he focuses on the mutual consent provisions. And then he talks about the question of who would vote, and I'm going to get back to that in a moment. And then he also says that there are limitations on immigration, labor, military activities, federal lands in the Guam Commonwealth Act that are inconsistent with the role of the federal government in relationship to the United States, and therefore it's not a relationship that would work. This is from Garamendi's testimony. He says, second, providing for a legally binding vote of the ultimate political status of Guam, in which only one group can participate to the exclusion of other U.S. citizen residents of Guam. So he's referring to what I think was an earlier part of the draft Commonwealth Act that gave the Chamorro people a special right to vote on the status that would be separate and apart from the vote of the non-Chamorro people, and I'm going to talk about that a little bit more in a moment. And it's interesting that by 1997, this provision had been changed, and in the 1997 version of the draft Commonwealth Act, the vote would be taken by all the people of Guam, but he's, I think, referring back to an earlier version here. So, ultimately, when you have that mutual consent idea, you're really more like a free association relationship. And of course, free association is an option for Guam. We have lots of places in the Pacific now with free association relationships. So with the United States, the Republic of the Marshall Islands, Federated States of Micronesia, Republic of Palau. So that's clearly an option that's there, but that option has its own sort of package to it, and so if you want that option, you've got to sort of have the whole deal. You can't sort of pick and choose different situations with regard to it. Now, in the 1997 version of the draft Commonwealth Act, and this, of course, there have been some changes over the 10-year period between 87 and 97, but here's the language that is in the final version of this proposal. So it refers to the inalienable right of self-determination of the indigenous Chamorro people of Guam, defined as those born in Guam before 1950 and their descendants. And then it goes on to say, but nothing shall be interpreted as depriving any qualified resident of Guam of voting in the plebiscite to be held on this matter. So, at least by 1997, there had been an understanding that everybody in Guam would need to vote ultimately on Guam's status. And so this provision, 102, refers to 1204, which does say the act will become effective upon the approval of a majority of the voters, referring to everyone in Guam. So I think that part of Garamendi's concern had been corrected, but the other parts were still valid. So then 102 goes on to say that the Chamorro language and culture and traditions should be protected and their economic opportunities and so on. And then it says, but even though the Chamorro rights are to be protected, other people will have rights too. So this is consistent, of course, with the requirements of the U.S. Constitution. And then it talks about the Chamorro Land Trust. That would be part of the package. Well, since then, so that's 1997, now it's 2010, there hasn't been too much in the way of movement on this question, and it seems like there's been sort of gridlock or stalemate or something on this question, and Representative Mordayo just recently summarized Guam's status by saying Guam is an unincorporated territory. Unincorporated because not all the provisions of the U.S. Constitution apply. We remain unequal Americans in a status where the Constitution does not fully apply. So an unincorporated territory, I mean, it's not a very elegant term, and it usually, I mean, historically it's referred, she's right of course, that it means that the entire Constitution does not apply, but it historically meant unincorporated. You were not incorporated, the plan was not for you to be a state. So those parts, those territories that were on their way to becoming a state were incorporated territories. And the unincorporated territories were those where the idea was that you would not eventually become a state. And so some people say Guam's status is the status of having no status. The U.S. Supreme Court looked at this issue in the years that followed the Spanish-American War, where we acquired these new island territories. And so there's a series of cases that are referred to as the insular cases. Many of you, of course, are familiar with these. And they sort of said, well, okay, these are possessions of the United States, but they're not really part of the United States. The Constitution's not fully applied. Many people view these insular cases as rather racist in nature because it seemed like it was the white people saying that the non-white people were not going to have full constitutional rights. It's still very unclear to figure out exactly what parts of the Constitution do apply in the 5 U.S. flag communities. This is still very much in debate. The Downs versus Bidwell case referred to those parts of the Constitution, those constitutional rights that are the sort of natural rights or the fundamental rights. The U.S. Supreme Court did have a list of the fundamental rights that do apply in the territories, apparently, but people are still debating as to which ones are applicable, which ones are not. Juries, for instance, were not fully applicable in the territories in these early decisions. And President Underwood recently said that obviously we want to move somehow in the direction of a more secure, stable status, and he emphasized that we want a relationship that cannot be changed arbitrarily, that would increase our autonomy, enhance our participation in federal decision-making, enhance our economy as well as our autonomy. So I think these are really the fundamental goals that probably are ones that the community would most likely like to move forward on. So I'm going to try, as we go forward, to give some ideas about how we might achieve the goals that he's laid out for us here. Okay, so we have these 16 non-self-governing territories under the UN system. These places have the right of self-determination, the debate here still seems to very much involve the question of the rights of the Chamorro people and the rights of the non-Chamorro people, and that seems to be something that causes people to have difficulty to really sort out exactly where to go next. The Chamorro population, according to the figures I've been looking at, seems to be about 37%. So not a majority. There are other people here. And of course, they have rights under U.S. law and international law, human rights, of course. So we have 65,000 Chamorro people. We have other, maybe 19,000 in the Northern Marianas, 93,000 outside the Marianas. So there's a good number of Chamorro people. And the ultimate question then is, when we talk about self-determination, who is the self that has the right of self-determination? This is an issue that people have struggled with around the world. And as I've thought it through, I